Thanks, Jess.
Okay, thank you everyone. Thank you again for attending this event as part of the 8th Annual Startup Boston Week Conference. I am Harish, and I'm going to continue to be your host today. First off, a huge thank you to Suffolk University's Sawyer School of Business again for hosting this conference for the second consecutive year now. As you may have noticed, this is the prime location in downtown Boston as a perfect hub for exploring Boston's innovation ecosystem and also learning from the industry's leaders. The goal behind our Startup Boston Week is to connect the entire Boston and New England community across all industries, all startup departments, and all bootstrapped and funding stages for 5 days of learning and connecting with one another. The team that creates Startup Boston Week is primarily volunteer, and all the folks working the conference here today are volunteering their time as well. So thank you for attending this conference. It is a labor of love, and we appreciate all your participation in shaping up the role for our startup community. This session is particularly sponsored by Lando and Anastasi LLP. So thank you very much for sponsoring this session. Startup Boston Week could not happen without the support of awesome partners like them. So thank you so much once again, everyone. And we'll now move on to the session, to the speakers. Thank you.
Thank you. Am I on?
Sounds good.
Can you hear me okay? All right. Hi, everyone. Good afternoon. My name is Andrea Reed. Can everyone? Oh, there we go. Thank you. Okay. I knew you couldn't hear me. Good afternoon. My name is Andrea Reed. I'm of counsel with the law firm Lando and Anastasi. We are a Boston-based boutique IP firm. So I'll be moderating today's discussion. Quick bit about my background. I've been outside counsel in practicing IP litigation, patent litigation, trademark litigation for about 15 years now. My technical background is in polymer materials and manufacturing. So anyone who wants to talk about that after, I love talking about polymer materials. Our goal for today is to give all of you the knowledge and the tools that you need to make good IP decisions for yourselves and for your companies, and also to know when it's time to call outside counsel to help you along with those as well. I'll introduce the panelists in just a second. Some quick housekeeping. We're going to target an hour. I'll take questions at the end for like the last 5 minutes, but anyone who has questions in the middle, feel free to raise your hands because we want it to be interactive and we want to make sure we're getting your questions too, not just what I think are your questions. And also because we have lawyers up here, I do have to say nobody is giving legal advice. We're not allowed to. You all know that. All right, so our panelists today, we have John Spangenberger. He's a partner, a colleague of mine at Lando and Anastasi. Amanda Cardona, an associate at Lando and Anastasi as well. And Jen just told me how to say her last name. I'm going to say it wrong. Karnakis? Karnakis, all right. She is the executive director of the Suffolk Law IP Center, so we're thrilled to have her with us. I'm going to have everyone up here give a 30-second elevator pitch with your own backgrounds because you can describe what you do better than me.
Great. Like Andrea said, a little close there. Like Andrea said, my name is John Spangenberger. I'm a partner in our patent division in particular. My background is in electrical engineering. So a lot of my work centralizes on helping companies to obtain patent protection for their inventions in the electrical engineering space. I attended Suffolk University, and now I'm continuing that cycle of terrorizing students. I'm also an adjunct professor here. So I love education. I'm very excited to share with you all today the things I love about IP. So thank you all so much for coming.
Great. My name is Amanda Cardona. I'm an associate at Lando and Anastasi. My background is in chemical engineering and material science engineering. I practice mostly patent prosecution, but I also have experience with licensing transactions, and more recently, I've been working with our litigation group as well.
Great. And I'm Jen Karnakis. I am the executive director of the Suffolk Law IP Center, and I'm also an adjunct professor here as well. I teach the Introduction to Intellectual Property course, but before that, I was a life sciences patent attorney for about 20 years. But I wasn't a litigator, so I wrote down what I'm going to say, and you'll probably see me reading from it. And I also am famous for saying I'm an immunologist, not a technology person. So if you ask me a question about software, I'm going to smile and nod and give you the best I can.
Did you say you wrote down everything because you're not a litigator?
I'm not a litigator.
I
so
am a litigator, and I wrote down everything.
Oh, I'm
so-
gonna read from it. That's what makes me not the litigator.
I am too. It's okay. Okay, this is great. So I like to start with an easy question to get everybody warmed up. My first question is going to be, what is IP? And I'm going to start with Jen on this because she told me that if you were to ask all four of us what is IP, we'd all give you a different answer. So I'm going to let you take that one.
That's what I always say to everyone. It's one of those things I think everyone thinks they know what it is, and then when I ask you to give me a pithy answer, they sort of stumble over the words. But what I tend to think of it as it's creative things of your mind, inventions, innovations, maybe not necessarily tangible. Sometimes it's a product. You have a patent, you have a bone screw or a medical device. Sometimes it's something you have to think about in theory. It's an antibody, but you can't see it. But it's anything that comes out of your mind, and you want to protect that.
John and Amanda, you guys answer.
Yeah. Not much to add to that. I mean, IP is an intangible asset, right? A product of the mind. So you could go downstairs to the bookstore and buy a physical copy of a book, and that's a piece of tangible property that you own. But the publisher or the author, they own the intangible asset of the copyright to make copies of that book, right?
Amanda?
I think those are both great answers. The only thing that I would add is that it's an intangible asset, like John said, but it covers a lot of your creative work, what you've been thinking of anytime you solve a problem or you make an improvement to something that already exists, or anytime you come up with a marketing strategy or marketing materials for your product or service. That is all intellectual property.
Amanda, people generally say there are 4 different buckets of IP. Do you want to briefly cover those so the audience knows where we're heading?
Sure, yeah. So there are 4 types of intellectual property. They include patents, trademarks, copyrights, and trade secrets. There are differences between these. There's some overlap as well. Patents generally cover inventions, so any new and useful improvement to a device, a machine, a system, or a process. Trademarks generally cover what are like brand identifiers. So anytime you use a symbol or a word to identify the source of the goods, that is considered a trademark. Copyrights protect works of authorship. So I like to think of it as creative works. When you design a website, you make a slide deck presentation, those are also protectable by copyright. Or the more traditional, you write a book, you compose a song, you perform a play that is recorded. All of those are protectable by copyright. And then trade secret is a category that covers any additional information. So it's any information that is useful by virtue of being a secret to your competitors. And this it's a wide range. It goes from know-how to systems as well, processes, but it also might cover customer lists in certain instances. So it's a bucket for any additional information that you can protect.
That's great, thank you. And we'll cover all 4 of those buckets, I like that word, today while we're up here. So let's talk about the importance of IP. And we're mostly going to be focusing on patents and trademarks today, but the importance of it to the startup ecosystem. So some people say, I'm so early, I'm just thinking about this. Is IP really something that I need to be worrying about right now, or can I just wait until later? I don't know, John, if you want to speak to that.
Gladly. Yeah, I mean, as young companies, right, this is geared towards startups. Young companies, often you don't have a lot of capital, you don't have a lot of brand recognition, you don't have an established customer base oftentimes. Often startups, their idea is the majority of what the company has, right? And so, of course, IP protection is important when IP is the cornerstone of your business. So to give some examples of where that might be useful, let me ask you a question, Andrea. Let's say I'm trying to get some money from you. I want you to invest in my company. Mm-hmm. And I say, you know what? Patents are kind of expensive. I'm not going to pursue patent protection. I'm going to put that money towards more R&D. So I'm not going to protect my IP. So if I come to you, Andrea, and I say, you know, if anyone comes along, any bigger company, they can steal my idea. And honestly, there's not a lot I can do about it because I don't have a patent. Can I please have a small loan of $1 million, Andrea?
Maybe a tiny loan, but not $1 million,
Okay.
because I'm worried.
Fair enough, right?
And what happens if you get sued?
Exactly right, yeah. So if you don't pursue patent protection, if you want to talk about short-term benefits, securing investing, that's going to be extremely useful in the short term, right? So many investors are not going to be interested in exposing themselves to all that risk in your company if they know that anyone could come along and steal your invention, right? If you want to talk about longer-term benefits, I'll tell you a tale of a client of ours, 2 different interactions they had before getting involved with us, our firm. This client decided, you know what, we're not going to establish a big patent portfolio. We're just going to go ahead and invest all that money in R&D. Not a terrible idea until another competitor came along and said, well, gosh, this company has no patent protection, so we're going to sue them for infringing our patents, and there's nothing that our client can do to stop it, right? So patents have defensive value in that respect, right? It's kind of like amassing your own arsenal so that you're a less attractive target for people to sue, right? Like Apple and Samsung, they could sue each other on 500 different counts of patent infringement tomorrow if they wanted to. And the only people who are winning in that case are the lawyers, right, who are litigating that. So, you know what, actually scratch everything I just said. Please, everyone should sue each other. Now, that client, that was a wake-up call for them. They experienced, substantial judgment against them, and there's nothing they could do to stop it because they didn't have any patent protection. Later down the road, they started getting some patents and eventually were acquired by a much larger company who said, well, look, I would rather buy this company and buy all of their IP and fold it into our business because we can't just rip off what they have because they have patent protection, right? So in the longer term, it makes you a lot more attractive as an exit opportunity if you want to be acquired. And in the near term, it's valuable for securing investing.
That's a great answer. Thank you. Amanda, I'll throw this one to you. How does a startup know what IP it has, and how do they know if it's valuable?
Yeah, so we talked a little bit about that before when we were answering the question of what is IP, but I think a decent shortcut to determining whether you have IP is when you're thinking about your product or service that you're going to be offering. Generally, a lot of companies will look to what is already available on the market. They might look at competitive products, look at similar services, and they might try to think about what's an improvement that I might make or what's a differentiator that I can implement that will differentiate me from what's already available. And I say that those are pretty good indicators of your intellectual property that's worthy of protection. In addition to that, we also talked about marketing materials, any visual aids, any visual information that you're putting out to your potential customers. That is also protectable as intellectual property. And I believe you also asked, how do we know if it's valuable?
You don't have to answer all my questions. It's okay. You can answer what you want to answer. That's all John does.
No, I can talk about that at least with respect to patents, because patents really, a lot of companies will, in their investor pitch, or for example, they'll go up to Shark Tank and they'll be asked, do you have patent protection? And the startup will just say, yes, we do, or patent pending, and they don't provide any more information. But there's a lot more information that someone needs to know to be able to decide how valuable and how extensive that protection really is, and investors will be looking at that information. And I think that when we think about patents, we really need to be looking at the claims of a patent, because that's where the inventors have laid out the invention in terms of steps or elements of a product, and the scope of the claims are going to provide the protection. So you need to think about how easy is it for my competitor to design around my claims, because if a competitor can easily substitute one element for another, that's not going to be as strong of a patent as if it's more robust and it covers more elements. You also need to think about how easy is it for me to tell if my competitor is infringing my patent. So some patents cover processes, for example, and these might be things that are performed in a manufacturing setting, in a laboratory, and those are usually under secured protection. There might be a situation where you have a patent, but there's no way for you to know without physically going to their manufacturing site whether or not your competitor is infringing, and that's just going to be more difficult to enforce, which is going to make it less robust of a patent than something that when you buy the product on the market, you can easily tell whether or not your competitor is infringing.
Thanks, Amanda. That's great. So, you know what? This is a good time to actually switch to patents and start talking some serious patent law. Oh, that sounded boring. It's not boring. It's very exciting. I'm going to take a poll. How many people in here have an issued patent already? How many people in here? I heard a maybe. That's all right. My next question was, how many people in here have a patent application pending? All right, we have some more hands for that. So let's talk about, Jen, I'm going in a line here. We got John, Amanda, Jen. Jen, next question is for you. Are there different types of patents? What are they? How does a startup know which one they need?
Yes, and so there's a few things that I always tell my students when they're in class. I'm like, the thing you're going to come out of this is you're going to have just enough knowledge to be dangerous. When you go out and you tell people, I have a patent, that means it's issued. But if you have a pending application, don't tell people you have a patent. So it's very much like a terminology thing. But when we talk about patents, there's two main types. Well, there's three. I'm going to leave out plant patents. If you have a burning question about plant patents, we can talk about it afterwards. But typically when we think about patent, probably what comes to mind is a utility patent. It has a use, it has a function. It's a thing, it's a composition of matter, it's a process. There's also design patents, which people don't think about sometimes, but that's something that's purely ornamental. It was the day that I figured out what was Apple versus Samsung that my law school friends all figured out what I did for a living when they called me and said, how does the corners that are rounded on the apps, my iPhone, lead to $500 million? And I was like, let's talk about design patent law, right? Because it's not the function of the apps, it's just the decorative nature of it. So there are two different buckets. But typically when you talk to people and they're talking about patents, they're usually thinking about a utility patent.
That's great. And what about provisional and non-provisional applications?
Sure. So there's and this gets also confusing, and people will talk about it. Provisional is like, it's a placeholder, right? It's not going to be examined, but it will become publicly available in the future if you convert it into a non-provisional. Non-provisional means this is the one I want you to look at. A patent examiner will pick it up. It'll go through a process. You go back and forth, and we'll go through what that process is. But often, I also tell my students in my class, Suffolk is really big on real-world experience. So when it comes out in our class, I say in the form of, this is why scientists and technology people hate the patent people, or this is why marketing hates the patent people. But when we talk about, if you think you have an idea, like we're talking about all these, like, how is it valuable? The hard part is, don't talk about it, right? You want to make sure that you've protected it. One way to lose patent rights is to talk about it, and we'll go through that in more detail. But a provisional is a good way to sort of, you set your stake in the ground. You're saying, this is what I think my invention is right now. It never gets, and then in 12 months, you can add more data, you can add more information, you can change the claims, but at least it gives you some protection. So I used to say to all my clients, before you go to that, meeting, I often joke, my mother raised me paranoid and neurotic, so being a lawyer was a fantastic career for me. Before you go to a meeting, they'd be like, Jen, it's gonna be fine. And then I literally had one client who, they went to a meeting on Friday and they realized that Monday that the people had stolen their idea and had filed their own provisional patent application, but we had filed on Thursday before the meeting. And they said, thank God we did that. I said, see, I'm annoying, but there's a reason why I'm annoying.
We're not annoying, and nobody hates us.
No, I'm talking about me,
fair.
not in general, me.
So, John, I'll ask you, when it comes to provisional applications and non-provisional applications, thinking of the audience here being startups, how would you think about the appropriateness of each of those different types of applications for them?
Yeah. So provisional applications are often a lot more valuable for startups because, first of all, provisional applications, like Jen said, they're more of a placeholder. They have less exacting requirements. That means that they're a lot cheaper, right? So we attorneys don't have to spend as much time preparing a provisional application because they don't need to be quite as robust as a non-provisional application. So for startups, when money is tight in the early stages of a company's development, often the provisional makes a lot more sense from a cost perspective. The other great benefit of a provisional application is that you can change whatever you want over the course of the year after you file the provisional application. Right, and so that's great because early in the early stages of your product development, you might have a product that looks one way one day, and then a month later you've decided, we're going to change up all of these critical features of the product and completely changes the scope of what your product looks like. So provisional applications are great because you can be a lot more agile in changing the scope of the content of the provisional application. Whereas with non-provisionals, once you file it, you're basically locked into what you've described in that document.
Thanks, that's a great answer. All right, next question. Amanda, I'm going to give this one to you. So how does a startup know if their idea is patentable?
There's a question in the
I'm sorry, I'll take your question. Or one of them will take your question.
Yeah.
She's bringing you a microphone.
Thank you very much. Very quick question, just to come back on your point about the provisional patent,
Yeah.
IP. So I'm just wondering, do we need, I work in a biotech field with biologics, you may be familiar with. So how much data do we need to actually file a provisional patent? Do you really need like concrete data, or if you have an idea, for example, that combines two already existing things, but from a different angle, sorry, can you just, based on the description of your thought, have this provisional patent filed?
Yeah,
Or
great.
do you need additional data and things to start writing it? Because I may need to think about quickly.
Yeah, that's a wonderful question. So it is more like the broader idea of what the invention is rather than getting down to specific data, figures, numbers. In fact, it's often not advantageous to put things like very specific data in a provisional patent application. Something to keep in mind with patents is that it's a quid pro quo. You know, you're in exchange for potentially having a monopoly on your invention by virtue of the patent being granted to you, you are describing how your invention works in its entirety to the public. So once your patent has expired, you have no more protection, and everything that you disclosed is complete public information. So oftentimes we actually want to be judicious about what we're putting in an application because knowing that it will eventually become public. So oftentimes it's not a good thing to include very specific data and numbers because you're sharing a little bit more than you would otherwise have to. So that's a long-winded response to your question, which is you only need a more general description of an idea. Amanda?
Thank you very much.
Yeah, I'd like to add just quickly, for life sciences, it's a pretty complicated field, and there tends to be a higher requirement for data than for example, consumer products. So for the provisional application, it's not required, but you probably do want to consider whether you're going to have enough data within the year period so that when you convert the application, you do have data at least to enable your claims.
Thank you very much. And just to follow up on that, and I'm done with this, and I'm sure maybe other people might be benefiting from that. So I'm applying for a grant from US, right? And one of the caveats is they don't provide any CDA. So basically, they don't have any way for you to secure whatever you're going to disclose with them. And if you don't disclose your invention or maybe your vision, right, they won't invest in you. So my question is, do you think then the provisional application is a must-have before even to discuss with them? Because the way I was communicating with them is that they said that it should be confidential because this is not the aim of the organization to share those information, but they have reviewers, and those reviewers are supposed to be confidential, but they are humans and they can show some leaks sometimes. So I'm just wondering more globally for anyone here in the room looking for grants from the US, right, NSF or others, if there's no CDA, if you think maybe the provisional application is a must-have.
We generally recommend, if it's possible, to file the provisional application before applying for the grant, but it's not always possible. It's best practice, it's answer.
We have another question over here if you want to.
I-
Oh, okay, wait, hang on. We have a line. Next question.
So when to apply for a provisional patent, and what is is the jurisdiction of both the patents the same? So if someone infringes on a provisional patent, can we sue them as we would have done if they infringed on a non-provisional patent?
Great question. So critically, when we talk about patent applications, that is different from a granted patent. So when we talk about provisional patent applications, a provisional patent application will never become a patent unless you file a non-provisional patent application. And if that is then granted to a granted patent, that is what you can use to sue alleged infringers. A patent application gives you absolutely no right whatsoever to sue anybody. Because it's just an application, right? So I think there's a misconception sometimes that acquiring a patent is a purely administrative action, that you submit an application and the US Patent Office says, yep, you check the boxes, rubber stamp. In reality, it's a substantive back and forth process where we negotiate with the Patent Office what the scope of that patent should be. So only once it's granted and all parties, us and the Patent Office, are in agreement, yep, this should be granted, this is novel, and you deserve a patent, only then can you take that and sue somebody. So to answer your question, a provisional patent application is mutually exclusive with a granted patent, and only a granted patent can be used to sue somebody. Does that make sense?
Yeah, thank you so much.
Perfect, my pleasure.
Oh, over here on my left.
Hello, my name is Rashid. Thank you for such an interesting topic. I'm working in software, and I believe the question I have is concerning a lot of people from the same industry. So let's say I'm developing an application, a software, and I believe it's kind of unique, at least at some points. So what is patentable in terms of general software application? Is it like the design itself? Is it a set of features? Or, I mean, like, definitely the code falls under copyright. But what can be patentable if I'm just making a software? Thank you.
Great question. And for a few $100s an hour, I can tell you it depends. This is the million-dollar question, right? In patent law right now, with the patentability of software. To be frank with you, it's a very heady and technical explanation that I think is better suited for a one-on-one conversation. It would take me 10 minutes to give you a very muddy explanation of where the state of the art is in the world of software patent law right now. The short answer is that it is possible to get patents on software inventions, but it is difficult, and only certain software patent applications technologies can be patented. You also mentioned copyright. It is very easy, on the other hand, to get copyright protection for the literal code of your software. But if you want to cover the higher level functionality of what software is doing, that would be the domain of patent law, and that's where it gets complicated. Would either of you like to expand on that at all?
No.
I think that's a great answer.
All right, we have another one.
Please, yeah. So can you comment on, excuse me, the thought or statement that, hey, a patent is only good as your ability to have the money that it's going to take to defend that patent, particularly when you're going against a bigger company?
Yeah, this is a question we get a lot, right? In response to that, I would say that patents are a known cost to give you some level of protection against companies. It's absolutely true that it is very expensive to defend against a competitor who is ripping off your idea that you might want to sue for patent infringement. But what's the alternative, right? That you have no protection whatsoever and they can trample all over you and do whatever they want. I am young and optimistic about the US legal system still. So I do have faith that it provides for protections in events like that, where it's a large competitor infringing on a patent. So there are things available to you, like if they're blatantly ripping off your invention and they know it and they're saying, well, yeah, but we have more money, so what are you going to do about it? There are extra remedies available to you in the way of things like triple damages or attorney's fees. So yes, it is expensive to defend yourself against a case of patent infringement, but you'd be in a worse position if you had no protection whatsoever, right?
So the second part of that would be, if you don't pursue a patent, are there things you can do in the way you operate and in the way you go to market which could provide some kind of relief against somebody infringing?
Well, I suppose you could pursue trade secret protection instead for some of your inventions, which...
By the way, it's software, yeah.
Okay, yeah. Yeah, so trade secret and patents, often you have to decide between one or the other, but they offer much different scopes of protection. So with trade secrets, for example, if a competitor is able to reverse engineer something that you are alleging is a trade secret, that's fair game. You don't have trade secret protection for things that are fairly reverse engineered. So I would say your options would be limited in the software space if you don't have any patent protection. And yes, you might have some large competitors who can use their capital to, pursue a potentially frivolous claim. But having a patent in your back pocket offers a lot of value in terms of deterring them from doing that, and potentially even an exit in the way of them wanting to acquire your company.
I'm sorry, last thing. So what in general, this might not be a fair question, does it cost to obtain a patent, and how long does it take for software?
Yeah, great question, and something we wanted to talk about.
Yeah.
Very ballpark, it depends on the technology, but maybe around $30,000 start to finish. How long does it take? About 3 years on average. Yeah.
So I was actually, I don't know if the moderator is allowed to answer a question, but when you first started, I have a practical comment on whether there's enough money to defend yourself in a patent litigation if you're sued, or if you want to assert your patent someday. Just from a practical perspective, it takes a while to get a patent, and by the time you go from startup to having gone through a provisional, to a non-provisional, to an issued patent through the prosecution timeline, many years could have passed at that point, and you might be in a very different position at that point, or maybe you've been acquired at that point, and the cost of defending or asserting in patent litigation is it's someone else's problem. So I wouldn't let the thought that, oh my goodness, I've heard patent litigation is so expensive, be a reason to not pursue protection if you can get it. So you're welcome. So Amanda, I was going to ask you about the requirements for patentability, so utility, novelty, non-obviousness, just so that we have a sense of what actually is patentable.
Yeah, like Andrea was mentioned, there are several requirements. The invention has to be new, which is, it has to be novel. It can't have been described in a publication or on sale. It also has to be non-obvious, which means that someone who has what we call ordinary skill in the art can't look at something that exists and think that your invention is just an obvious modification of it. That's a very simplistic answer, that the bulk of what we do as patent prosecutors is argue that an invention was not obvious, but that is something that usually the examiners will try to come back with. In addition to that, it has to be described in the text of the patent application in sufficient detail to enable someone to make and use the invention. And that's also kind of a nuanced requirement because, as you know, we were talking about trade secrets, and there are certain elements which you can still keep as a trade secret. So finding that balance between enough disclosure and maintaining confidential information is an art as well. And then the last requirement is that it has to be, the invention has to be part of it cannot be part of one of these categories that the Supreme Court has deemed are not eligible for patentability, at least under US law. And they include algorithms like software generally, as well as naturally occurring products is another category. And again, like we were just talking about software, that's also a nuanced answer, but that's the short version.
Thanks, Amanda. Can you recommend any searching resources for startups who might want to get a sense of what's out there? What have other people patented? What do I have to worry about because I don't want to infringe on anyone's rights? Is that something that they can start on their own?
Yeah, definitely. There are a lot of different search platforms. You know, the U.S. Patent and Trademark Office has one, European Patent Office, the World Intellectual Property Office also has one. My personal favorite, though, is actually Google Patents because it's a very simple search bar, like we're all used to using Google for our search bars, and it also provides machine translations of international applications. And there's also an option to review non-patent literature, which is like scientific publications, articles that may also be relevant to the technology.
I want to know, are there any types of documents that startups should start collecting now if they think at one point they're going to file a provisional or a non-provisional? Anyone can take that.
Sure. We often see people prepare what's called an invention disclosure form, and that's generally some answers to very basic questions, you know, what's the invention, what was known, and it also includes information on who the inventors were. So when you're thinking about, I think we're going to get into this in more detail in a little bit later, but when you're thinking about what your claimed invention is going to be, anyone who made a contribution to the claimed invention is an inventor, and those individuals are going to have an important role during prosecution by transferring ownership, for example, to the company. So it's important to be able to identify who the inventors are from the beginning. Other than that, just a description of how to make and use the invention is sufficient.
That's great, thanks. And then what about deadlines? Are there any, John, you can probably answer this one. Are there any deadlines or timelines that should be top of mind?
Yeah, and they come sooner than you might expect. Bottom line, high-level summary, you need to have a patent application filed before any kind of disclosure, any kind of public disclosure. So if even an offer, for example, to sell your product to another company privately behind closed doors, that would trigger the bar before which you would have had to file a provisional application or a non-provisional application. So before ever telling anyone about your idea, except within your own company, you should be filing a patent application before that time.
Thanks. Amanda, do you want to talk about the timeline for prosecution? I know, John, you gave a rough idea of how long it takes, but what specifically should they expect in terms of filing until actually getting their patent?
Yeah, I think John mentioned 3 years. The Patent Office has a goal of issuing a patent within 3 years from the filing date of the non-provisional application, but there are ways to delay or speed it up based on your needs. And also the 3 years is kind of a pretty, it's a goal. It doesn't always happen. It depends on the way the prosecution is going. It may take much longer. But if you think about filing first a provisional application, you can count 1 year from that date. After that, you can file a non-provisional or an international application. If you want to delay prosecution further, you can file the international application, and then you have another 18 months to file your non-provisional application. So at this point, we are 2.5 years in. And then is when their 3-year target begins. So there's a pretty straightforward way to delay prosecution as much as possible while you try to get funding. On the other hand, if your goal is to have an issued patent very quickly, you can file the non-provisional application from the beginning. And there are ways to expedite prosecution. You can file what's called a Track 1 application, and I believe within about 2 years they try to get those issued. Right?
Yeah.
So it depends.
So do we want to move from patents to trademarks? Do we want to keep talking about patents? I want to talk about what the audience wants to hear about. I have 2 questions.
Yeah.
We'll start here.
Yeah, thank you. I'm still trying to find a way. I believe like a lot of people here work in software too, so it might be interesting for not only for me. So let's imagine I still want to protect my software with a patent. From what I heard, it's kind of like tough to do it with utility patent. So I'm wondering, how about design patent? Can I file and use design patent to protect my user interface? Which, I mean, like at some point it will become very polished and usable. And now I don't want my competitors to take advantage of just like looking at my UI and just doing the same thing, which is easy to do. So I'm wondering, is it possible to use design patent to protect user interface of the software? Thank you.
Yep, you sure can. And you could also pursue copyright protection for it as well. So yes, absolutely you can. And that's much cheaper than a utility patent.
And can you please give the numbers and timeline for design? As you mentioned, patent is like $30,000. How much will be for design patent?
Do either of you want to take that one?
It's much less than a utility patent. That's the short answer. If you're able to provide the images in the drawings that are going to be used in the application, you can also greatly reduce the cost of filing, because a design patent application is primarily the drawings, and there's a very short description attached to it. And I believe that prosecution tends to be quicker for design applications than utility applications.
Yeah, it tends to be a lot more straightforward. With utility patents, usually there's a back and forth with the patent office for about 1.5 years, maybe say 3 back and forths on average, but it can go theoretically indefinitely. With design patents, usually it's at most 1 back and forth. It's a lot more straightforward to get those granted. So, but otherwise, I think Amanda answered it perfectly.
Okay, we had another question. Oh gosh, we have lots of questions. 1, 2, 3, 4. Anyone who has the mic can ask the question.
I'm going to go first because I'm going to tail into this guy's question. So when someone comes along and rips off his UI, right? I know a gentleman down there was asking about costs. You read about this stuff online, and they provide wild ranges, right? 600,000 to 3.5 million. What's it going to cost him to go defend that patent, whether it's design, utility? and I know everyone's looking for numbers, range. And then when you read about these things online, is that borne by both parties? Or is who actually foots the bill for this?
Good question. So who foots the bill? The general rule is that everyone pays their own attorney's costs, okay? Even if you win the case, that doesn't mean that the other side has to pay your attorney's costs, as a general rule, unless there's especially flagrant circumstances, which Andrea, I'm sure, could speak to better than I as a career litigator. In terms of what it would cost, unfortunately, it runs the gamut. Yeah, I mean, well, it could be as simple as sending them a cease and desist letter. So, you know, you have an attorney spend $1,000 writing up a letter and sending it to them. Sure. Yeah, yeah. And then litigation, I mean, Andrea, you could probably give better figures than I on the upper end.
My figures are pretty much what you just cited, and it could be lower and it could be higher. No. Nope. That would be your own one party. Yes. But it depends on so many things, right? It depends. How is this a competitor you really care about? How much are they going to fight? If they just roll over and say, fine, forget it, it's not worth it, you know, we don't have the money right now to pursue this ourselves, then that's not going to cost you as much. If it's someone who's really going to fight until trial and take it to appeal, I mean, that's going to cost you a lot more. So also the complexity of the claims, the number of patents involved, like when we're quoting out what a litigation might cost after a client gets sued and comes to us and says, what are we looking at here? We say how many patents are asserted. We look at the claims and say, is this really, really complicated? Can we resolve this in court, or can we go to the patent office, have the patent office take a second look at it? If it's our client's own patent, then you know we of course don't want to go back to the patent office and have them take a second look at it. But that's often what defendants are going to do. So it's a long way of saying that a lot of the cost is driven by how serious your competitor wants to fight. So unfortunately, that's out of your control. But yes.
I relate to the software question that's getting asked. So what does mean in terms of data here? Because in his case, I relate to him quite a bit. Design code is not data, then what is data? And especially from a defensive perspective, in the sense, not a litigation perspective, but many investors come and ask this question, do you have a patent? And we say patent pending. What does that mean, data perspective? What is the data can be explained to us, something that we can future defend it?
Good question. So if I understand your question properly, you know, what would we want to put in a patent application? Whereas what would we not? And the what would we not includes very specific data. And I understand your question to be, what is that data? So for example, let's say you have an algorithm that takes in these 3 different inputs and it weights them all differently to come up with some output, right? What I just described is what we might want to put in the patent application. So we say, look, we take these 3 inputs, we assign some weight values to them, and then we come up with some output based on that. So that's what we put in the patent application. What we wouldn't necessarily put is, here's the specific numbers that we would use for those weights. You know, that sort of data that gets down to the very fine granular level of the algorithm, that we would want to keep out. Now, big surprise, the patent attorney, I'm going to say, consult with the patent attorney as to what constitutes that data you'd want to keep out, and what is the higher level idea that you would want to be the subject of the application. So, you know, we have day-to-day experience of dealing with the patent office and understanding what level of detail they'll require versus the level of detail that's really hurting yourself by including. Does that answer your question? Yeah. Perfect.
I have a question about visual artists. And I mean, I'm confused about whether it's going to be trademark, copyright, patent, and now you have digital visual artists. So could you talk about this?
Yeah, gladly.
What, want to move to trademarks and copyright?
That's exactly what
I
I
was
was
just
gonna
thinking
say.
we have people online too who I know we promised trademarks and copyrights. So we should
idea.
move to that. I promised Jen she could have some of this. So and you haven't been talking enough. So I'm gonna shift some questions to you. Tell us about trademarks. What are they? When are they appropriate?
So trademarks, again, I always tell my students, if you are looking for a bright line rule, IP is not really the area that has bright line rules. And but in terms of trademarks, there's sort of these mantras, and I always tell them it has to be a source identifier. It has to distinguish your goods from other goods in the marketplace. So even if you don't know what the source is, as long as you know it's different. So my perfect example of that is like, Marshmallow Peeps. You may not know that it comes from the Just Born company, but you know that Peeps are different than whatever a Peep competitor is or things like that. But a trademark could be a word, a symbol, a combination. It could be, there are trademarks for sounds. There are trademarks for smell, like Play-Doh. And the minute I said that, you all just pictured, or imagine the smell of, there are colors can be trademarked. So the original canary yellow of the 3M Post-it, different things. The red sole of a Louis Vuitton shoe, those are trademarks. But trademarks, you have to be able to prove that in the marketplace, it has that distinguishing characteristic, that the consumers in that channel of goods understand it to be a particular brand and it's different from other brands in the marketplace.
That's a great answer. And then what about copyrights?
So again, I have all these mantras. So the mantra for copyright is it's an original work of authorship in a fixed, tangible medium. But one of the things that IP people love to do is not use the dictionary definition of words. So when I talk about tangible, like tangible in the definition is more about like tactile, right? The ability to perceive by touch. But it just means in the copyright sense that you can take it and show it to somebody else at a later time, whether that's a second later, a nanosecond later, 10 years later. That's what we mean by fixed tangible medium. So it could be, when I talk to my students and they're all much younger than me, I say, oh, I grew up with, first it was vinyl records, then it was, cassette tapes, and then it was CDs, and now it's like everything's an MP3 file, right? So we have things that were tactile, right? I had my CD, I scratched it, I was in trouble, I couldn't print the song. Now it's all in the cloud. Again, software, so I'm going to use like big words, but it's this idea that even if you're a visual artist, it's typically, that's when we think of copyright, we think of things like movies, books, poems. My favorite is there's also protection for pantomimes and choreography. So apparently the Marcel Marceau lobby was huge when that got added into the copyright statute. But for you all in business, it could be your website, your materials, your slide decks, things along those lines. Those are also things that are works of art, works of authorship in a fixed tangible medium.
John, Amanda, what do you want to add to either of those, the trademark or the copyright?
I think that was a great answer. And just to summarize, a trademark identifies a product that's in the marketplace, and a copyright covers any other creative work.
Yeah, and I'll just add that to your question, copyright would be the primary form of protection for visual artists.
Do we have other questions from the audience on trademarks or copyrights? I want to make sure we're answering what's on your mind on here.
Can something generated by AI be copyrighted?
Not in the US. So thanks to a case that involved monkey selfies, yes, monkey selfies, the current rule in the US is that you have to have a human author. So of course, this is like forcing the Copyright Office to think about modernizing our laws and thinking about how to do things. So right now they're soliciting comments on AI and copyright, but there's a few cases where if you have a whole work, so the one case they had, it was a graphic novel where the humans wrote the text and they had the AI images. So the Copyright Office said, you can protect the whole work, but you can't get a copyright on the individual images because those were not generated by a human author. And if anybody wants to know about the monkey selfie, I'm happy to tell you all about that story.
Stay after for more on that.
Yeah.
Question in the back?
To follow up on that, what do you define as an art generated by a human author? So you can take a monkey selfie, for instance, and change a few pixels that might not even be visible to the human eye. And does it constitute as work by a human author?
It has to be how different is it, right? Do you have enough? The law of copyright is you have to be original and creative. Is it just enough to make that spark of creativity? But then in terms of, I'm not familiar with the case law, to be honest. I haven't practiced in a few years, so if there's anybody, feel free to jump in. But in terms of that, if you're making sort of insubstantial changes, but there are some, and this has also been, the Supreme Court has recently come out with cases like in the Andy Warhol case, it's changed the nature. It used to be this idea of transformative art. So there were artists like Andy Warhol who would take people's pictures and make that pop art, right? And they would change it. And it used to be, sort of the general rule was that was fine, right? You are making your own creation. Now there's sort of an added layer of, are you doing it for a commercial purpose when you're doing that? So I have a lot of friends that are, I'm a huge nerd. I'm a scientist who became a lawyer. I'm a nerd, big surprise. So all my friends are nerds and they want to do like fan art and fan fiction. And I'm like, that's great. Then they want to sell it on Etsy. And I was like, now you're moving beyond the realm of I'm like, there's a risk. And so, and things like that. But I can talk more about that later afterwards if you want to.
Any other questions on trademarks or copyrights? We have
Hi,
two.
I have one, just a quick one. When you're thinking about consumer goods, is it worthwhile, aside from the brand itself, to trademark the actual formulation of the product? Or like, how would you think about that?
When you say formulation, are you talking about a consumer good like maybe a makeup product?
Exactly, like like skincare, makeup, whatever. Like,
Yeah. Great question. So you would not trademark that, but you would potentially pursue patent protection for it. So you could pursue a patent for the actual composition of matter, it's called, of the product. More likely, you would use trade secret protection. So you would not disclose what your exact formula is. You would keep it secret, keep it a trade secret, in fact. And then as long as it can't be reverse engineered, you can indefinitely have that makeup protected. Yeah, exactly right. So trade secrets cover things of commercial value which you are keeping private. So you may have seen the big Waymo versus Uber trade secret case in which an engineer from Waymo went to Uber and he took all of his this confidential information from Waymo and used it to improve Uber's products. So that's trade secret misappropriation. That resulted in a $250 million judgment. So trade secrets are very powerful. They're also the only form of IP that have criminal liability. So I think that engineer also went to jail for 1.5 years. So trade secret protection is very useful. The caveat is that if competitors fairly reverse engineer your product, that's fair game. Whereas with patents, it doesn't matter how a competitor comes across your idea or if they reverse engineer it or not. If you have a patent, you can block anyone from practicing your invention, regardless of whether they copied you or came up with it on their own. Yeah.
John, what are some of the best practices for helping keep your trade secret private?
Yeah, good question. So you need to take reasonable steps to keep your trade secrets secret, okay? So for startups, this is especially concerning, right? Like if you work in a co-working space, you need to be careful in terms of just physical security that you're keeping any of your documents locked up. I mean, literally locked up, right? You might want to be wary of what you're showing on your screen when others are around. But one of the most powerful tools that you can take advantage of are things like employment agreements and non-disclosure agreements. So you need to be careful when you're hiring folks that you have an employment agreement that explains, here is what information is confidential. You need to be very careful not to disclose this confidential information to anyone. And then in terms of things like non-disclosure agreements with, say, a supplier, a partner that you might want to work on or work with, as part of that business relationship with someone you're contracting with, you're going to need to disclose some confidential information, probably. And so you need to set the expectation with them, this needs to remain confidential, you can't share this with anyone, right? So all that to say, you need to take reasonable steps to keep your trade secret secret, or else if you don't take those reasonable steps, then it can become public and there's nothing you can do to stop anyone from using that trade secret.
That's a great answer. I think we have one more question. Yep. Oh,
So-
two more questions.
So once I file a patent and then I'm writing a white paper or creating a deck of slides or creating an image to explain that algorithm, so do I need to file for a copyright as well as the patent or just the one?
They're totally separate from one another. So yes, you would definitely want to file a patent application before disclosing anything in the form of a white paper or slides.
Okay.
But once you disclose that white paper slides after you filed your patent application, you could 100% pursue copyright protection for those. But it's not as though there's any dependency on the patent application per se. They're totally different tracks of protection.
And there's no requirement to register. The copyright exists as of the date of creation. If you want to add the copyright symbol, that just helps put others on notice, but you already have the copyright prior to registration.
Yeah, and to add on that, Amanda's talking about the C in the circle, that means this is a copyright. As compared to the R in the circle, that means this is a registered copyright. So it's kind of a step above, and for that you do need to go through a registration process.
Okay, so what is the difference between the two, provisional and non-provisional, kinda?
I would divorce them just to not confuse the tracks.
Okay.
With copyright, anytime you create any work of authorship, that automatically has copyright protection. So you could theoretically put a C on every single PowerPoint you've ever made, every Word document you've ever made. So you don't have to do anything to acquire that protection. But if you go to the patent office and you register it with the patent office, which is quick, cheap, easy, then you can use the R symbol.
Okay.
So as an example, I have copyright in this outline that I've been reading from and writing on. I have it. It automatically exists. I'm not going to go register it because nobody cares.
Just want to add one thing, just to be clear, that your copyright is when you have the moment of fixation. It's not just when you have an idea, it's when you put it in that fixed tangible medium. And then, and there's different terms. So the reason why a patent is, we say about 20 years from your first examining application. But a copyright, if you're a company and you do it in a work for hire, it could be 95 years or 120 years. A person, it's the life of the author plus 70 years. So it's a long term. And there are some benefits for the, you can use the C with the circle, and that's actually for both the registered and the, any copyright, even if it hasn't been registered with the Copyright Office.
So it used to be that you would put something in a sealed envelope and mail it to yourself. Is that still good? Or?
Oh, it's to show like what the date was, yeah. Like in terms of like you have that as a, like you could have proof that you would do that. Now it's you can keep a notebook, you can date your journals, it's and things like that. It's no longer. And there used to be formality requirements, and then like a lot of people lost their copyrights because they didn't put the C on it, including like Tolkien and Picasso. And then when we entered the TRIPS agreement, they all got it back. So we had to play nice with everybody, and they got their rights back.
We have one more question in the front that's been waiting. Thank you.
Hi, thank you. Just to go back to the Gen AI question, just to be clear, if I take something, an image, I put it on a T-shirt, I start selling the T-shirt, then I don't have any coverage. Someone else can take that same image, put it on a poster or T-shirt. Is that correct?
So you created the image, or you asked ChatGPT or whatever, the Dolly or whatever it's called, that you asked them to create it for you?
Well, a little more specific. I uploaded a bunch of images. I had it created based on those images, and so there's a fair amount of prompting on my part of what I wanted it to output. It did the output, and then basically it's an image. I want to sell that on something.
Could you transform the image a little bit and make it like, could you add to it? Could you incorporate into another design? If it's just purely what comes out of the generative AI right now in the United States, it's not considered protectable by copyright.
And so if I printed out like a black and white version and then I colored it myself or something like that?
Here's my favorite lawyer answer of, it depends, right? So as I tell my students, right, it really is a matter of like, you could have, it's what the, it's ultimately what a judge or a jury decides. If you've ever had jury duty, that can be a scary process, but I'll leave that to the, so, there's no bright line rule to be like, if you make these number of changes, you're gonna be fine. In some jurisdictions, they might say that's fine. In other jurisdictions, you might say that. And then it goes to the Supreme Court and they wreak havoc, and everything we thought for 10 years is now out the window.
And then sort of an additional part, is there anything right now that I have to disclose if I used AI to create something?
I think that we as attorneys have an ethical requirement to make inquiries as to whether you used AI to produce whatever your creative works are. Because, for example, with the Copyright Office, if AI was used to create something, it's not subject to copyright protection. And so it would be a violation of my ethical duties to file that on your behalf with the Copyright Office if I didn't make reasonable inquiries as to whether you used generative AI to create it.
Okay.
So no, there's no box you check that says I didn't use generative AI, but when you're filing, you're making an assertion that no, I did not actually use AI. This is an original work of my authorship.
Okay, so even if I just put like a C on there or something, that doesn't really count?
Correct, because it's anything created by AI is not created by a human, and therefore it's not subject to copyright protection. It'd be like, I don't know, making this up. If you're walking along the beach and you find some driftwood that's been shaped by the ocean, just because you pick it up, I don't know, this is how my mind works. Just because you found it, you picked it up, it wasn't created by a human. It's not like anyone could get copyright protection for that piece of driftwood, right? Because it was created by the ocean, not by you.
So I'm getting the hurry up and finish signal over here, and he's talking about driftwood.
Yeah.
So we're going to stop it here. So just, I was going to recap, but we covered so much today. You can go to the USPTO's website. They have great searching resources. Google Patent, another great searching resource. And then the last resource I want to mention is on Lando and Anastasi's website, we have an entrepreneurship center with all sorts of common Q&As that we get all the time. We put it all up there online. Go and check it out, and hopefully if there was anything today you didn't get answered, you can find it there. So thank you everyone for listening. Thank you to the panelists. Thank you to Startup Boston for having us. I hope that was helpful and enjoyable.
Thank you all. Thank you.
All right, thank you everyone. Thank you panelists. This was a great session. So yeah, we have 2 more days of Startup Boston Week left. A lot more in store for both today and the 2 days. We have a startup crawl that is happening at 6 p.m. And the next event in this room is going to be at 3:45 p.m. It's called Ready for Growth, How to Build Your Finance Function for a Scale Post Series A, and it's presented by Harmonic.
We're trying to do that.
So if you're sticking around for that event, please stay here and have your QR code ready, and we'll be coming around to scan you for that session. For those of you joining us virtually, please stay online, and I'll see you in a few minutes.